We'll hear argument next in Case 18-938, Ritzen Group versus Jackson Masonry. Mr. Lehman.
Mr. Chief Justice, and may it please the Court. 28 U.S.C. Section 158 provides that district courts shall have jurisdiction to hear appeals from final order of bankruptcy judges entered in cases and proceedings referred to bankruptcy judges under Section 157. The order in this case merely determined where the parties would litigate Ritzen's contract claim. Under Section 158, such an order is not a final order entered in a case or proceeding. As this Court determined just 4 terms ago in Bullard versus Blue Hills Bank, the fact that an order disposes of a proceeding is not, despite what Respondent and the government contends, the test for determining finality. That, in the words of the Court, slices the case too thin. Rather, an immediately appealable order is determined by considering the larger process at issue and whether the order is final by examining whether it alters the status quo and fixes the rights and obligations of the parties. In Bullard, the relevant process was the plan confirmation process. Here, the relevant process is the claims adjudication or the claims allowance process under Chapter 5 of the Bankruptcy Code. As in Bullard, the order here did not resolve the larger process. It did not alter the status quo, nor did it fix the obligations of the parties. On the contrary, it simply continued the automatic stay, so the underlying claim would proceed in bankruptcy court. In arguing otherwise, Respondent and the government badly misperceived the role of the automatic stay in bankruptcy cases. The automatic stay is not itself one of the substantive processes of bankruptcy. It is a utility provision that supports the operation of these other processes. In fact, it was Jackson who argued that Ritzen's motion for relief triggered the claims adjudication process, claiming the stay motion constituted an informal proof of claim. Such an order changes little, and in the words of this Court, does not alter the status quo or fix the rights and obligations of the parties. Contrary to what the government has represented in its brief, Section 158 was not actually enacted in 1978. In fact, Section 158 was enacted in 1984. The reason this, what appears to be a small mistake, I believe is a very significant matter because it misunderstands the history of the bankruptcy jurisdictional framework.
As I understand what you've just said, you're not contesting that this was a proceeding. You're just saying it wasn't a final order in the proceeding. Is that right?
That's correct. As this Court noted in Bullard, there's an endless number of contested matters, many of which are not are of a less significant nature. The question is not on what is a proceeding, but what is on an immediately appealable proceeding. And in Bullard, the Court looked at the process to determine whether or not that had the indicia of finality.
And when would it become final? At the end of the case?
We would submit that it would become final under this Court's test that when the status quo changed and when the rights and obligations of the parties were fixed.
And when would that be?
Well, for example, Rule 8002 actually lays out a very good framework for final orders because it determines what orders cannot be extended in terms of time frame. The first, under 8002D2A, is the granting of the automatic stay cannot be extended, but the denial of the automatic stay isn't mentioned. The second one, the authorization of a sale under 363, for example. The third one, the authorization of financing under 364. It goes back to the Court's reasoning in Bullard, where the Court determined that there is no symmetry in finality, that in fact a final rule is often determined such as the grant of a motion to dismiss, but not a denial of a motion to dismiss.
Maybe you could simplify this a little bit for me. There's a denial of relief from the stay. And when can the party who sought relief from the stay take an appeal contesting the denial of relief from the stay?
When, in the words of this Court, the discrete dispute between the parties are resolved.
When would that happen?
Yes.
Yeah.
in this particular case, at the end of the claims adjudication process. It was the respondent that said that the claims adjudication process was triggered by the motion to lift the stay.
Yeah, okay. And at that point, isn't the issue of whether there should have been relief from the stay moot?
No. This Court has recognized at least 3 different occasions that that is not an unreviewable decision, that that is the decision, as a result of the single appeal rule, that has to be respected and preserved.
Okay. What relief could be granted at that point?
Just like this Court did in the Oberding case, the Court could vacate the decision and send it back. Importantly, under Rule 502J, it's specifically allowed under the Bankruptcy Code. Under Rule 502J, an order that a claim that has been allowed or disallowed can be changed. An allowed claim can be disallowed. A disallowed claim can be changed.
Okay. So the Court says there should have been, on appeal, there should have been relief from the stay. So what does that do for the party who sought relief from the stay? I think your argument has to be that undoes everything that happened since that point, right?
Well, with respect, it's no different than a motion to remand, a motion to transfer venue. It's a motion to deny a denial of a motion to abstain.
Well, it's a little different because the bankruptcy has gone on, right? The bankruptcy is concluded, and part of the bankruptcy is you're divvying things up, and depending on how much this person gets, that person gets more. But now you say you've got to go back and start over with respect to one person's claim. I don't understand how you can unscramble that egg.
But this is something that bankruptcy lawyers deal with every single day. It can be done through a variety of matters. But as a practical matter, Your Honor, given the length of the typical bankruptcy and the length of the appeal, it wouldn't be unscrambled before the bankruptcy process was ended in the first place. As a practical matter, as we cite to you in our reply brief, in the footnote on page 19, the average bankruptcy case is concluded in 7 months. The average appeal, the first appeal, takes 9 months. In this case, the second appeal took a little bit less time than that. But so as a practical matter, there is no such thing as undoing, because whether you took the appeal at the moment that the stay relief was denied or at the moment that the claims adjudication process was ended, you were still going to have an appeal that extended well beyond the plan confirmation process. And that's why bankruptcy lawyers deal with this issue of claim contingency all the time. And they work with reserves just like they did here. And the parties agreed that they would not object to the plan on the condition that this appeal could go forward. And there was a security set aside in the amount of $400,000. Now, we don't believe that that's the entirety of our damages, but that's the security that the parties agreed to. And if that's less than if that's not enough to cover our damages, and that's the risk that we took in agreeing to that claim.
Would you have had the right, if you chose, not to waste your time in adjudicating this in bankruptcy court and could you have chosen to appeal immediately after the injunction was denied?
Your Honor, I missed the first part of your question.
Assuming you wished not to incur the expense and time of adjudicating this in the bankruptcy proceeding, could you have chosen at the time the injunction order denying the request to lift the stay was issued, could you have appealed then?
I believe that under 158, there's an interlocutory operation, 158A-C, as well as 1292A. By definition.
So the answer is yes.
Yes, Your Honor.
So
as an interlocutory appeal.
So isn't that a different question? Since you accept the responsibility that you could have appealed, isn't the issue whether you should have appealed? And isn't there a split on that question among the circuits?
Well, Your Honor.
Because what you're basically saying is I didn't have to.
With respect, Your Honor, I believe that there are 2 very important reasons. First of all, it's not a matter of having to. It's a matter of whether the Court would have allowed us to under the interlocutory standard. And given the environment that we were in, we did not believe an interlocutory appeal would have been granted. But moreover —
so you're answering me no.
Well,
that you couldn't have. I don't know what you're arguing.
With respect, the question was, could we have appealed? Theoretically, we could have filed an interlocutory appeal. As a practical matter, that's only with leave of court. And we did not — and so it wasn't something automatically that we could do. And so, second of all, with respect to the second appeal, the reality was the relationships between the parties were going to result in the second substantive appeal. The question is whether the court is going to compel the parties to appeal or whether the parties will be able to consolidate their appeals at the end of the discrete dispute.
What's the difference? Is it the case that a creditor says to the bankruptcy judge, Judge, I don't want to be here. Go lift the automatic stay. And the judge says, you're right. Now, can the debtor appeal?
Yes, Your Honor.
Okay. If the debtor can appeal then, why can't the creditor appeal if he reaches the opposite conclusion? In both cases, I imagine the immediate appeal is given because in many instances, though certainly not all, getting rid of a creditor or keeping a creditor will change in a pretty significant way the nature of the final plan. Now, what have I said wrong?
With respect, this Court addressed that very issue in Bullard. And the Court said that confirmations of a plan change the status quo and set the rights and obligations of a party. But denials, while the parties continue to negotiate, do not do that.
They don't do that? Why not? If we have an imaginary case where a creditor who happens to make this motion has $100 million and everybody else taken all together has $3.50. Okay? Now, it seems to me that getting rid of that creditor would change the nature of the final plan. Wouldn't it?
If the merits.
I don't think Bullard was addressing that issue.
Not exactly, Your Honor, but it was certainly addressing the question of the symmetry that the Court
Okay, so what's the answer to that issue? I'm not saying symmetry automatically makes the same result. All I am saying, it seemed to me, being very much an amateur in this field, but you are not, that the reason for allowing the initial appeal, were they granted, is because of the enormous change that might work in the nature of the plan. And if that's the reason, the same thing is true when you deny it. Now, that's what I'm getting as a question. I'm not giving you an answer. I want to know what you think.
And under the Bullard standard, I do not believe the denial changes the status quo. As this Court said, the stay remains in effect. Final does not determine the state of affairs.
I see. So, in other words, in my case, $100 million gone out of the estate, $3.53 left. That didn't change anything.
No, the granting does change it.
No, now we have it the other way. $100 million is there, as opposed to the $3.53. That changes nothing.
The Court does not look at the significance of the matter in determining whether or not it's
final. I didn't say it did. I just said the reasoning seems to be similar if my reasoning is correct. That's why I put it as a question.
And I would submit the Court answered this question in Bullard, that unless the status quo is changed, that it's not a final order, because it doesn't end that substantive process. If it's a $3.50 creditor that is otherwise excluded from the estate by the granting of the stay, that's a final judgment with respect to that creditor. If it's a $1 million creditor and that's denied, the status quo is still not changed. The status quo continues, and that creditor continues within the bankruptcy process. Now, I may have misunderstood the Court's question, but I believe that was an attempt to answer it.
Okay.
It does assume some facts and evidence that I'm more of an expert, but I will defer to the Court. I would continue by suggesting that the government's characterization of bankruptcy law is misunderstood. Not only does the government misunderstand the framework for the jurisdiction, overlooking the fact that 158 was not passed in 1978, but was something to remedy 1293, which the Court in the First Circuit, in Re Sacco Low, which this Court has cited favorably, had to address. 1293 did not use the word proceedings. 1293 was drafted in a way that required a final order, but without the concept of proceeding. And there the First Circuit said, we have to – we look back over 200 years in how this Court has looked at bankruptcy orders and recognized that in some cases, some bankruptcy proceedings are different, are treated differently. And as a result of that, Certainly, Congress did not intend to change this under 1293. A year later, Congress fixed that problem with a very elegant solution in 158. In 158, they included the word proceeding to go back and recognize over the last 200 years that there would be some proceedings in bankruptcy that would be final. However, they included a word, a guardrail, to ensure that that did not get out of control. And that guardrail was the word final, a word that this Court had used and interpreted since Congress enacted the Judiciary Act of 1789, and a word that brings all the soil of 1291 with it. Final is a term of art. Final has 200 years of definition behind it, and Congress fixed the problem of 1293 through 158. But to that end, 158, the finality consideration, as this Court recognized and as even the Solicitor General recognized, this finality requirement has significance, has import. It's not just the last order in the sequence. It's not just the order that disposes of a motion for an extension of time. It's not the order that disposes of a retention of professionals. Those are not matters that aren't deemed final. Those don't change the status quo. Those don't fix the rights and obligations of the parties. Second of all, I believe the government is mistaken about 362E.
Before you go on to that, I'm not sure I quite understand why, if you agree that the motion for relief from the stay is a proceeding, why an order saying, no, I'm not granting relief from the proceeding is not final?
Well, as this Court noted in Bullard, there are literally countless numbers of proceedings in contested matters. But it stretches the concept of finality to assume that the order that disposes of all those proceedings meets the qualification of what this Court called an immediately appealable order.
So what if the order denying relief from the stay says, and this is the final word on this subject, this is not going to be reexamined? It's not final?
No, because the stay by its very nature is fluid. As even the Sixth Circuit recognized, facts and circumstances can change. Even the Respondent cited a case from the Tenth Circuit at page 38 of their brief where they talk about how the Court had granted relief from the stay, 10 months later reconsidered it. The First Circuit in the Atlas case, the basis for their ruling, because there were competing there was a first-to-file rule question between two district judges. The First Circuit said the order of the stay relief isn't final. Things can change that would cause the Puerto Rican judge to decide that the Virginia judge should go forward. And at that point, the bankruptcy court will have to once reconsider whether the stay applies, whether the stay is final. But the stay by its very nature is fluid. It's no different than the way this Court analyzed a motion to deny a request for abstention under the Gulf Aerospace case versus Mayacamas. There, the Court rejected the concept of the collateral order doctrine because the first requirement was that the issue be conclusively resolved. And the Court looked at that and said, abstention, 3 months from now, the district court may decide that the state court matter should go forward. And so this cannot be a final order by definition because it doesn't conclusively resolve the issue. Now, I would like to also point out that with respect to the injunction that is claimed here, that's defeated by the very terms of the rule. Under 363C2C, the code says that the stay expires upon the discharge. That's something that this Court recognized just last term in Taggart versus Lorenzen, that there is a distinction between the automatic stay and the injunction. There's no, and even going back to Celotex in 1995, there's no textual basis to believe that there is a permanent injunction with the stay that by its very nature, and even Congress in the same legislative history that the government cites, admits is temporary. And then finally, I would argue that they're mistaken about the application of 362E. 362E is a very different part of the motion of the stay than 362D1. 362E relates to actions against the property as opposed to actions against the debtor. Now, in this case, we sought relief under 362D1 for cause. We did not bring basically what was an in rem action or an action regarding a secured party under relief under 362E. There was a lot of ink spilled on the question of 362E, the injunction, the fact that there was a preliminary hearing and a final hearing. I would submit to the Court that those concepts are not applicable here. What is critical here is that the Respondent dragged the motion to lift the stay into the claims adjudication process. It was the Respondent who, in responding to the motion to lift the stay, objected as an informal proof of claim. By objecting as an informal proof of claim, the Respondent is triggering the entire claims adjudication process. And, of course, after that point, we filed an adversarial proceeding. They filed an adversarial proceeding. We had competing proofs of claim. That is the claims adjudication process under Chapter 5, 501, the submission of a claim, 502, objection, 503, the resolution of that claim by the Court. That is the broader substantive bankruptcy process that was resolved here. But this Court has never recognized that decisions about where to litigate are final orders when they're denied. When they're granted, that's one thing. That changes the status quo. That dismisses the case. But when they're denied, those are not final orders. And finally, I would also point out that from a policy perspective, the question here, as the Court looked in Bullard, the Court noted that if the Court had ruled otherwise, it could possibly give the debtor greater leverage over the creditors because the debtor could hold up the creditors with a threat of appeals. That same dynamic applies here. If you allow creditors, or I should say if you force creditors to take appeals on early preliminary matters, the definition of which is impossible to define the limits of under the Respondent's suggested rules, you're going to tilt the playing field with respect to those negotiations. Debtors are in bankruptcy for a reason. They have limited resources. And to allow or force creditors whose motions are denied, I'm not talking about the motions that are granted, that's the exchange we had earlier, but creditors whose motions are denied to immediately take those appeals is going to change the way the bankruptcy process works. Now, I think that we've even seen that right now with the Sixth Circuit.
Most of the courts of appeals have that rule, though.
Well, with respect, Your Honor, I believe that rule is based in most of those cases on an outdated anachronism. Under a former bankruptcy rule, Rule 701, the reality is the only two courts to have considered this in any detail within the last 10 years has been the First Circuit, and that was 3 months after their ruling in the Bullard case that this Court then affirmed, and the Sixth Circuit. The other circuits, I would submit, their rulings are largely based, and if you look at the majority of them over the last 2 decades, it would be grants or denials in a very summary, often in a footnote or in dicta, as opposed to a careful analysis of this issue. In reality, under the old bankruptcy rule, under 701, they had to file an adversarial proceeding in order to challenge the stay. Under the new bankruptcy rules, under 4001, that's a contested matter. It's not an adversarial proceeding. But in filing an adversarial proceeding under Rule 701, there was often a claim for relief. Claim 1, just like a declaratory judgment action. Claim 2, breach of contract. And in many of those cases, the underlying merits were determined. When the rules changed in 1984 from 701 to 7001, challenges to stays no longer were raised as adversarial proceedings. Instead, they were raised under Rule 4001 as a contested matter. So it's understandable that courts in the 82 to 84 circa were deeming a motion to lift the stay in an adversarial proceeding context as a discrete substantive dispute between the parties that often resolved a discrete within that proceeding.
Your theory under the Bullard test is that the denial of relief from the stay does not alter the status quo for the creditor.
Your Honor, it doesn't alter the status quo for either one.
And why is that on the status quo? I guess this might depend on how you define status quo, but it's going to prevent the creditor from enforcing judgments and seizing property, and the creditor is going to lose money. So I guess that depends on status quo, but they're going to have effects.
No, the status quo was determined at the date of the filing of the bankruptcy.
Right.
It was originally dating back to the filing of the bankruptcy. And as this Court noted in Bullard, when the plan confirmation was denied, the stay continued. The status quo did not change. What we're contending is nothing changed in the bankruptcy court. I'm sorry.
Thank you, counsel. Mr. Dunham.
Mr. Chief Justice, and may it please the Court, Section 158 of the Judicial Code provides for a district court's jurisdiction over final decisions and orders that are issued in proceedings. In this case, it appears as though Ritzen has conceded that a stay relief motion and a notice to the debtor and a hearing on that motion constitutes a proceeding. So the only issue now is whether or not that order issued by the bankruptcy court was indeed final. With respect to finality, this Court can simply borrow to the age-old tradition of what finality means under Section 1291 of the Judicial Code, and that is whether or not the order leaves nothing else to do except for execute upon the judgment, in this case, the decision. The bankruptcy court made it very clear that upon entry of the order the order denying the motion for relief from the automatic stay, there was only one thing to do, and that was to have the claims adjudication process